Hello everyone, a very warm welcome to all of you. I, Dr. Shikha Dhiman, Assistant Professor, Department of Laws, Guru Nanak Dev University, Amritsar, is here in front of you to deliver a lecture on the topic Citizenship Amendment Act 2019, Well Locked to Secular Democracy, a Discerning Analysis. Let's begin with an introduction. India is considered to be one of the oldest civilizations in the entire world, with a kaleidoscopic diversity and assortment in its rich edifying tradition as well as affluent cultural heritage. This cultural heritage can be witnessed through different forms as people of different religions and traditions are living all together as citizens of India since decades. The legal claim of citizenship of the country is an impulsive concept which can be only put to practice controlled by the state to serve the larger interest of its citizens. The Indian Constitution provides for a single citizenship for all its citizens. Our Constitution significantly deals with citizenship without any discrimination on the basis of religion. However, it is noteworthy to mention here that the provisions relating to citizenship are one of those provisions of the Constitution of India that came into force since the day of adoption of the Constitution, that is 26th November 1949, while many other provisions came into force on the day of commencement of the Constitution, that is 26th January 1950. The members of the Constituent Assembly intentionally incorporates a comprehensive provision through Article 11 of the Indian Constitution for the central legislature to make any law on citizenship. Also, because citizenship is listed in the Union list, it implies that only the Parliament has the exclusive jurisdiction to make any legislation in that regard. Accordingly, the Parliament enacted Citizenship Act 1955, which got amended 5 times before 2019, that is in 1986, 1992, 2003, 2005 and then in 2015. The outcome of these amendments was to taper down the broader concepts of citizenship in India. Most recently, the Act got amended in 2019 and the impending of Citizenship Amendment Act 2019 has shaken the relationship between citizenship and secular character of the nation. The country, through its constitution, also provides for constitutional supremacy and not the parliamentary supremacy, which implies that the Parliament cannot override the rights of citizens by going far from the ethos of the Constitution of India. Therefore, before making any legislation on citizenship, parliamentarians need to ponder upon its consequences on citizens as well as on non-citizens residing in the country. Now, let's discuss the conceptual framework and constitutional provisions relating to citizenship. India, like any other modern state, consists of 2 types of people, that is, citizens and non-citizens. Citizen of an Indian state is a full member who enjoys all civil and political rights like voting rights, right to hold property, etc. He also enjoys full membership of political community, whereas a non-citizen does not. Citizenship is the right to have the rights. Citizenship is a legal status determined by the Constitution as well as legislations. It carries certain advantages and rights like post of President, Prime Minister, judges of Supreme Court, High Court, Governor, etc. and some duties that are fundamental duties. Citizenship means the relationship between the individual and the state. There are 2 theories that justify this relationship, namely just soli, that is known as liberal theory. That is, wherever a person is born, he becomes a citizen. And the second theory is just sanguinis or blood relationship theory. That is, where a person is related through parents or grandparents through blood ties and he acquires citizenship accordingly. The Indian leaders, while drafting the Constitution of India, always favored the idea of just soli because they opined that the concept of just sanguinis is a racial concept and against the ethos of Indian setup. But with the passage of time, as the amendment took place in the original Citizenship Act 1955, the concept of just soli was abated and the idea of granting citizenship moved towards just sanguinis. Furthermore, there are two contrasting and different views of citizenship as are stated. Number 1, liberal individualistic conception. It focuses on man's economic nature. Citizens are sovereign, autonomous beings with their duties to pay taxes, obey the law, engage in business, defend the nation if necessary. Citizenship is based on reason for the pursuit of enlightened self-interest. Citizens are essentially passive politically. This theory may lead to a degeneration of public spirit. Second is civic republican conception. It focuses on man's political nature. Citizenship is about democratic participation which can channel legitimate frustrations and grievances and bring people to focus on matters of common concern. Citizenship happens in a public sphere. Citizens are active politically. It may lead to the free rider problem in which some neglect citizenship duties. As far as citizenship in India is concerned, it follows the idea of liberal individualistic citizenship. The ideals of such type of citizenship are mentioned in Part 2 of the Constitution of India, which are discussed now. Article 5, that is by domicile. Article 6, that is citizenship of certain persons who have migrated from Pakistan. Article 7, rights of citizenship of certain migrants to Pakistan. Then next, Article 8, rights of citizenship of certain persons of India origin residing outside India. Then Article 9, persons voluntarily acquiring citizenship of a foreign state not to be the citizens. Article 10, continuance of the rights of citizenship. And last, Article 11, that is Parliament to regulate the right of citizenship by law. In pursuance of Article 11 of the Constitution of India, the Parliament enacted the Citizenship Act 1955, which provides for the modes of acquiring Indian citizenship. These are as discussed. Section 3, citizenship by birth. Section 4, citizenship by descent. Section 5, citizenship by registration. Section 5, subsection 1, bars citizenship by registration for illegal migrants. Section 6, citizenship by naturalization. Section 6, subsection 1, bars citizenship by naturalization for illegal migrants. Section 7, citizenship by incorporation of territory. In order to understand the Citizenship Amendment Act 2019, its legal implications as well as the use of the word illegal migrant, we need to understand the citizenship by birth as stated under Section 3 of the Citizenship Amendment Act 1955. Let's discuss Section 3, citizenship by birth. Subsection 1. Every person born in India on or after 26 January 1950 shall be a citizen of India by birth. Exception, Clause A. Father or mother possesses immunity from suits and legal processes. Clause B. Father or mother is an enemy alien. This amendment in 1986 came into effect from 1st July 1987. Either of his parents is a citizen of India at the time of his birth. This amendment came in 2003 with effect from 3rd December 2004. Both the parents are citizen of India, or one of the parent is a citizen and the other is not illegal migrant, entered India without the travel documents, visa, etc. According to Section 2, subsection 1, Clause B of the Citizenship Act 1955, illegal migrant means a foreigner who has entered into India, number 1, without valid passport or other travel documents and such other document or authority as may be prescribed by or under any law in that behalf, or number 2, with a valid passport or other travel documents and such other document or authority as may be prescribed by or under any law in that behalf, but remains therein beyond the permitted period of time. Hence, this was the status of acquiring Indian citizenship by birth before coming up of the Citizenship Amendment Act 2019. Now let's discuss something about Citizenship Amendment Act 2019. It was passed by the Indian Parliament during winter session on 11th December 2019 and was enacted into a law on 12th December 2019. The amendments made by this Act are highlighted as under. First point, Section 2 of the Citizenship Amendment Act 2019 inserted a proviso clause in Section 2, subsection 1, Clause B of the Citizenship Act 1955, which is read as follows. Provided that any person belonging to Hindu, Sikh, Buddhist, Jain, Parsi or Christian community from Afghanistan, Bangladesh or Pakistan who entered into India on or before 31st day of December 2014 and who has been exempted by the central government by or under Clause C of subsection 2 of Section 3 of the Passport Entry into India Act 1920 or from the application of the provisions of the Foreigners Act 1946 or any rule or order made thereunder shall not be treated as illegal migrant for the purpose of this Act. Next, inserted a new section, that is Section 6B after Section 6A of the Principal Act, which states in its Clause 3 as on and from the date of commencement of the Citizenship Amendment Act 2019, any proceeding pending against a person under this section in respect of illegal migration or citizenship shall stand abated on conferment of citizenship to him, provided that such person shall not be disqualified for making application for citizenship under this section on the ground that the proceeding is pending against him and the central government or authority specified by it in this behalf shall not reject his application on the ground if he is otherwise found qualified for grant of citizenship under this section. Further, provided that the person who makes the application for citizenship under this section shall not be deprived of his rights and privileges to which he was entitled on the date of receipt of his application on the ground of making such application. Now, on a careful analysis of these amendments, it can be opined that the people who have come from Muslim-dominated countries of Pakistan, Afghanistan or Bangladesh and have stayed in India for 5 years are eligible to apply for Indian citizenship. But in this regard, two important questions that arises are, why only 6 religions have been taken? And second, why only these 3 countries have been taken? In response to such questions, the government gave a very firm answer. For the first question, the Union government alleges that the people from these 6 religions have been facing religious persecution, that is, treating someone unfairly and cruelly because of race, religion, political belief in these 3 Muslim majority countries. Hence, it makes a moral duty for the government to provide protection to such people, and therefore the government passed Citizenship Amendment Act 2019. For the second question, the government claimed that as these countries are Muslim majority countries, so the persecution is done only against non-Muslims and not against the Muslims. It is so because the Muslim dominating countries cannot persecute the people of their own religion. In response to government's reply, it can be seen that if government is trying to safeguard the interest of non-Muslims who, according to the government, have faced religious persecution, then why the word religious persecution is not mentioned expressly in the Citizenship Amendment Act 2019? Furthermore, if the government is taking persecution as a criterion, then why it is prima facie discriminating against illegal Muslim migrants from these 3 countries, as they too might be facing some form of persecution. For instance, Ahmadiyya sect and Shias face discrimination in Pakistan even though they belong to Muslim community. Also, there is an exclusion of persecuted religious minorities from other religions like Sri Lanka, Myanmar, Tibet, etc. Rohingya Muslims and Hindus face persecution in Burma. Hindus and Christian Tamils face persecution in Sri Lanka, and the list goes on. It has become one of the most controversial legislation since the commencement of Constitution of India 1950. There are many arguments that stand for and against the Act. These arguments have been raised up in the Parliament, in media, and even on the streets by the people. but the common man like us are still not aware of the short-term and long-term consequences of this Act. The arguments revolve only around one provision of the Act, that is Section 2, subsection 1, Clause B. Let us analyze some points of arguments made in favor and against the Citizenship Amendment Act 2019. Now, we will be discussing first of all the arguments that goes in favor of Citizenship Amendment Act 2019. Number 1. Non-violative of Article 15. Article 15 is applicable to citizens only, and the CAA, that is Citizenship Amendment Act, is for non-citizens only. Next, not violative of Article 14. There are two tests under Article 14, that is, reasonable classification test is a two-step test which provides there must be a classification based on intelligible differentia, that is, capability of being understood. Intelligible differentia must have rational nexus with the object of the statute. In the case of CAA, classification done is twofold, that is, first, between the theocratic states and the other, and second, between the persons who do not profess state religion in such states and others those who profess. Accordingly, first step is complete. Next step is the rational nexus with the Act. As far as the statement of objects and reasons is concerned, it mentions that CAA is to provide the privilege of citizenship to the identified persons, and such an object of the Act cannot be achieved without making the classification in question. Hence, CAA fulfills both the steps of reasonable classification test. Test of manifest arbitrariness is a test that requires the law to conform to norms which rational, informed with reason and guided by public interest. CAA proceeds on the grounds that religious minorities in these theocratic states are most in need of protection. So, the arguments are as under. Inclusiveness are insufficient to meet the high threshold of the manifest arbitrariness test. Presumption of constitutionality. The law always recognizes a presumption of constitutionality of the statute. It was stated by the Supreme Court of India that the mere fact of inequality in no manner determines the question of constitutionality. Then, citizenship is not mandatory. It is the discretion of the state in extending or not extending the citizenship to such non-Muslim illegal migrants as it is not an obligation. The state needs to consider various other factors before conferring citizenship to such class of migrants. Next, power with the Parliament. This Act was made in pursuance of Article 11 of the Constitution of India, which provides discretionary power to the Parliament to make any legislation in relation to acquisition and termination of citizenship. Next, CAA is not making any class of persons worse off. Rather, it is making persecuted class of persons better off. Arguments for that is, inclusiveness is basically an argument in favor of future amendment of Citizenship Act and not a fight for striking down a privilege given to persecuted persons on humanitarian grounds. It is contended by the supporters of CAA is giving citizenship to some sections of people and not taking away citizenship of anyone. So, genuine citizens of the country need not to worry about this amendment. Government went on saying that Islam has been declared as the official state religion of these three countries by various constitutional amendments, and therefore, Muslims are unlikely to face religious persecution and cannot be treated as persecuted minorities. The government also contended that the partition of India failed to safeguard the interest of minorities in Pakistan and Bangladesh. After independence, Pakistan announced itself to be a Muslim state, whereas India announced itself to be a secular state. This act of the government is an attempt to make cordial relations with the Pakistan and to protect the minorities residing there. Now, we will be discussing the arguments that goes against the Citizenship Amendment Act. Number 1. It is against the spirit of Constitution. Some believe that the Constitution in its preamble enunciates upon secular character of the country, and secularism is the basic ingredient and essential feature of the Constitution. CAA violates this constitutional ideal as it is providing citizenship on religious basis. It embraces a secular contract. India is a nation that comprises of people belonging to different faiths, ideologies, races, castes, etc., who enjoys their citizenship in a stipulated way. Providing citizenship to anyone on religious grounds seem to be a retrogressive idea in today's world. Since the advent of country and constitution, people have been granted citizenship, and those who join later are to be governed by the citizenship laws and constitutional provisions. Therefore, granting citizenship by asking people to prove it after almost 70 years makes no sense at all. Another point, it violates the provisions of Part 2 of the Constitution. Article 9 states, no person shall be a citizen of India by virtue of Article 5 or be deemed to be a citizen of India by virtue of Article 6 or Article 8 if he has voluntarily acquired the citizenship of any foreign state. CAA is allowing citizenship to those people who had voluntarily acquired the citizenship of Pakistan, Afghanistan and Bangladesh at the time of partition. Hence, it is clearly violating the constitutional provision because it sounds illogical to provide someone with Indian citizenship who had already been enjoying the citizenship of any of these three countries voluntarily. Another point of argument, it violates Article 14 and 15 of the Constitution. The former talks about the equality before law and the latter talks upon the prevention of discrimination on the basis of religion. But CAA is providing citizenship by violating between non-Muslims and Muslims as well as between three countries, that is Pakistan, Afghanistan and Bangladesh on one side and other Muslim dominating countries on the other side. Another point, sanctioning two-nation ideas. Earlier, it was during the days of independence when the idea of two nations was proposed. But history witnessed that idea being dumped into bin. The national leaders always disapproved the theory of two nation that divides India into Hindu Mahasabha and Muslim League. Once again, this dividing line of two-nation theory through the advent of Citizenship Amendment Act can be seen in India as it is discriminating citizens of religious grounds in order to provide them Indian citizenship. Another point, communal division. In 1905, the Britishers divided Bengal on the basis of communal demography. But however, it was taken back in the year 1911. Another instance is of British government granting separate electorates for varied sections in 1932, which was again revolted by the national leaders and was then rectified through Pune Pact. Now, it is the Citizenship Amendment Act which appears like communal division and it is being combated by the people unless it is taken back. December 31, 2014 in Citizenship Amendment Act, there has been misunderstanding of Section 2, subsection 1, clause B of the Act. It is not providing citizenship to all the persecuted Hindus, Sikhs, Buddhists, Jain, Parsis, Christians of Afghanistan, Pakistan and Bangladesh. In fact, it is allowing citizenship only to those who have entered India on or before 31st December 2014 and that too who have been given legal protection under the existing legislations for their stay in India on a long-term visa. Another point, religious persecution absent in Citizenship Amendment Act. No doubt, the government tried to help out the religiously persecuted persons from these three countries, but the Act does not mention anything about this. Had this been the real intention of the legislatures, then they would have definitely used the word religious persecution. Therefore, the absence of the word religious persecution from the Act makes it open for anyone to apply for citizenship. Another point of argument, religious persecution with non-Muslims. The government opined that Hindus, Sikhs, Buddhists, Jains, Parsis and Christians are religiously persecuted in Afghanistan, Pakistan and Bangladesh. But the question is about its authenticity. There may be many Muslims who are persecuted in Afghanistan, Pakistan and Bangladesh, but no provision for their protection has been made because it is deemed that Muslim dominating countries cannot persecute any Muslim, which itself stands illogical. Furthermore, there may be many Hindus, Sikhs, Buddhists, Jain, Parsis and Christians in Afghanistan, Pakistan and Bangladesh who have never been persecuted, still they are getting relief in India. Hence, the idea of government to grant citizenship only to 6 categories of people on the basis of religious persecution is absurd. Another point, Citizenship Amendment Act for limited number of refugees. According to the data given by Intelligence Bureau, the number of beneficiaries from this act may be just 31,313 from all the communities, that is 25,447 Hindus, 5,8076, 55 Christians, 2 Buddhists and 2 Parsis. So, it is not a big number for which such a big step and controversial legislation is drafted. Another point, danger to national security. There are many agencies around the world that are working against India. Those agencies may send their agents under the domain of religious persecutors from these 3 countries to India, who may then harm the nation in different ways. This issue had already been taken up before the Joint Parliamentary Committee. Citizenship legislation destroying the nation. Yugoslavia, the nation which was termed as laboratory of citizenship, played a lot with its citizenship laws. Consequently, after so many amendments in its citizenship law due to political upheavals, the country got divided into 7 countries in 1991. During the last 2 decades, Indian citizenship law got amended 3 times, that is in 2003, 2005 and 2019. Such amendments will make some illegal migrants as citizens and already residing citizens as migrants or refugees, especially those who could not provide any evidence for their citizenship. So, this is just an act of destabilizing the nation and making it crucial as well as dangerous for the citizens of India. Then comes the question, why CAA and NRC again? What is the need? More than 130 crore people are already residing in India and enjoying the Indian citizenship. The combination of CAA and NRC is a tool which is used by the government to deny citizenship to many citizens on some technical grounds. The question is, why after 7 decades of independence, there is a need to verify the citizenship of citizens? The logic to find out a few lakh infiltrators through this whole whipping seems unreasonable and will lead to same doom as of tracking black money through demonetization. Resultantly, nothing fruitful will be the outcome, and only crores of citizens will enter into needless inquiry by the government. The views of Assam and other northeastern states. After the passing of this act, many violent demonstrations have been witnessed in Assam and other northwestern states, fearing that the granting of Indian citizenship to illegal migrants will lead to loss of their political and cultural rights, thereby rousing further migration from Bangladesh. Another issue, detention centers. Once implemented, CAA will begin with its process of citizenship verification. The people who will be screened out will be sent to detention centers, as they cannot be deported back to their respective countries. Subsequently, a time will come when there will no way out except to grant them citizenship. Then what is the need of this amendment and bringing such a concomitant into the society? Also, these detention centers will lead to modern slavery, and the detainees will be treated as bonded laborers. If this happens so, then the fundamental rights enshrined under Article 23 of the Constitution of India will be violated, thereby undermining human dignity. Another problem, that is of burden of proof. According to the provisions of the law, it is always the accuser who is to prove beyond reasonable doubt and not the accused. In the present case, it is the government who is alleging to find out infiltrators in the country. Then why 130 crore people living in the country are compelled by law to prove their citizenship? Another issue, large sum of money. It has been estimated that in order to effectively carry out the implementation of CAA and NRC in India, approximately 54,000 crore to 1 lakh crore will be required. With such a decline economy of ours, it will be a huge burden on the country with no sagacious rationale. So, this is the end of the first part of this topic, that is citizenship, and we will discuss some another important aspects of this topic in the next module. Till then, stay safe, take care, God bless you. Thank you so much.